Good afternoon everyone, my name is Uday Kumar Reddy. Today I am going to explain about the group presentation. We are assigned for the topic Permanent Trustee Australian Limited versus Stout and others 1999. So in this, the case is Permanent Trustee Australia Limited. The applicants has filed as case under section 442 under corporate law regarding the lease of ground floor 452 470 Flinders Street, Melbourne. The recovery of the property is also placed under the section 441. The lease was given by the owner in 1995. After the purchase of property by Trustee Australia in 1998, who became the owner of premises. In 1999, 4th of January, the lease was transferred and also stated that it will be effective from 7th October 1998. In the normal course, the term of the lease would expire in July 2005 with 2 5-year options. Background of the case is in 1991 March 26, Permanent Trustee issues notice by stating the non-payment of rent which is due by 4 months from the December to March 1999. The value is around $51,458.38. It states that if not vacated in 14 days, the stated within the period is trustee would enter premises. This notice was expired in April 9 and 1999. Again in March 31 gave notice for breach of property, and this stated with section 146 property law of 1958. This stated that it is $41,343.75 billion. It was not paid by the party. The company would take over the property without notice in 14 days if not vacated. The notice became void in 14th April 1999. On 6th April 1999, a meeting was organized with two representatives named Kenneth John Stout and Robert Michael Scales. They both are directors for the job. In spite of new directors, the alleged breaches were not brought forward and continued for the business. Later, with the constant meeting in the company and about the tenants, were series of negotiations and law enforcement wasn't unsuccessful. The stance of case: the lease was terminated and this was issued by the council of members with the permanent trustee. This stated that the rent was not paid and breaching the Code of Property Act. This was included in section under 146. It is also challenged the appointment of the directors. This was challenged with section 146, where the notice does not satisfy the requirement of the section. This also states that there was no mention of statements for remedy of breaches by the tenant. Since the section under 146 requires a remedy statement for Counter Glass Mechanisms Private Limited. Two things that are considered: first, the law of rights which permanent trustee mentioned for these branches cannot be exercised. The section 146 property law act is not being mentioned properly. It means that the breach which is alleged on the company on the provision of section 146. The section aspect is regarding the notice appointment of administration which are subjected to post control. Coming to the discussion, the lease was not terminated at the beginning of the administration on the morning of 6 April 1999. The lease was terminated pursuant to clause 10.1.7 by re-entry continued by the demand for possession contained in the solicited letter of the afternoon of 6th April 1999. A permanent trustee has a present right to opposition of permissions, which right it might be enforced by re-entry or by action for possession. The impact of this statutory moratorium insofar as it concerns property leased by the company at the beginning of administration is to be found principally as SS 443B and 441F, 440C, 444F and 444D. Section 443B regulates the terms upon which the company may, during the administration, remains in possession of land where at the beginning of administration it was in possession of it under an existing lease. Section 440C, which holds the leaser from instituting consent with court intervention. Permanent trustee, a leaser of land, seeks declaration that 440C does not apply to it by reason of 441F found. In alternative relief under Section 440C, a convenient starting point there was Section 441F, which is in the terms of entered into possession or assumed control of property used or occupied by or in possession of the company, or be exercised by any other power in relation to the such property for the purpose of enforcing a right of the owner or leaser property to take possession of the property or otherwise recover it. Nothing in Section 437C or Section 440C prevents the receiver or other person from performing a function or exercising a power in relation to the property. Coming to the conclusion, finally Section 146 was not intended and it not projected properly. The use of Section 441 and 440 were not properly discussed. In the end, they conclude that no good proposed in the achieved form of the proposed deed, they will reject it. In that case, no serious hardship will be caused to permanent trust